Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that's been designed to address the critical and sometimes contentious issues that are facing your work and business life. Legal information, practical solutions, and straight talk about a wide variety of issues that are affecting consumers and businesses. Today we're going to be discussing affirmative action. A college case about school admissions is the current hot topic. In October, the court heard a challenge to the race-conscious admissions policy of the University of Texas. They don't have a decision about that. It might come any day. It might come as late as June. So we'll be talking about college admissions, but certainly other admissions policies and hiring policies. So I think while this is initially undertaken to offset some horrendous policies to start with, let's go over the basics. First, let's introduce from Bazar, Grasso law firm in East Providence, Jackie Grasso, and to her right, David Bazar.
Hi, Debbie.
Okay, what exactly is affirmative action? Let's get a little background before we get into the cases.
All right, so it's also called positive discrimination. It was originally enacted as a policy from John F. Kennedy, back in 1961. And it was, the purpose of which was to prohibit any entity or individual receiving federal funds, a contractor or a subcontractor, to prohibit them from discriminating individuals on the basis of race, origin, gender, sexual orientation, or religion. So that's really that was the original intent. Fast forward to today, now it's applying to schools, and when basically this, like the Texas case that you're talking about, the schools are using affirmative action as a policy for admissions, and in a particular case in Texas, they're challenging the constitutionality of that.
So civil rights, as Jackie was saying, under Kennedy and then Johnson, were designed to say, let's level the playing field for people so that there's no discrimination based on those factors. And then affirmative action was actually designed, as Jackie was saying, to bring it up a level and say, okay, we've had some groups of people who have historically been discriminated against, and it's not enough just to level the playing field. Sometimes we have to actually do something to advance the cause of those different groups, and that's how affirmative action came to be.
Of course, it's been debatable, it's been debated, it's been contentious, because some people are wondering whether or not it actually accomplishes what it set out to do. Might it actually be hurting the very people it was intended to help? But in either case, there are many who are the detractors who are saying, this isn't positive redress, this is reverse discrimination. And of course, I guess one of the earliest cases, and you'd probably be able to cite it better than I, the one that happened in Michigan with the law school
well, there's actually one before that.
And there are two before it, sure.
Bakke, wasn't Bakke versus California or something one of the earliest ones? Yeah, maybe even before that. And I don't remember the details of the Bakke case, but I remember that was one of the first challenges to affirmative action, where I believe he was saying he was denied admission to a medical school, if my memory serves right. And it was because he was not taken as a white male, being discriminated against because they were having a policy of looking to take people from those groups that Jackie had cited that had historically been discriminated against. And that was the first challenge, and it was a chink in the armor, so to speak, a little bit of affirmative action, but they left the tenets in place. And then you can fast forward a little bit to Michigan, which was the law school and the undergraduate school cases.
Near and dear to your heart, so you could have probably addressed the case, but you could also speak to how it might feel to be the one denied based on the fact that you had a better score and a better GPA, and yet denied admission because you happened to be not black but white, not white, or you weren't Hispanic or whatever. So what do you think? Comment on that, if you will.
Well, the way I view it is being denied because of race, if you want to look at it that way, because of the enactment of affirmative action. I feel it's a constitutional violation because now you are depriving me of my fundamental right to an education. And he was going to a public institution in that particular case. And you feel as though there's preferential treatment because of affirmative action, and even though you were trying to redress a wrong, which was discrimination, now you feel as though you are the one that is being separated.
Right.
It's worked in reverse. It's called reverse discrimination by some people.
Some people, that's what Bakke started with that phrase, and that he was being discriminated against in reverse. The Michigan cases, there were two. There was one against the law school and one against the undergraduate school. And they were treated very differently because they used the factor differently, the race factor or the religious factor or whatever it is. In the undergrad school, I guess they get so many applications that they just did a point system. You got a point if you got a certain GPA or above. You got a point if you had a certain SAT score or whatever it is that they used. And then they assigned an extra point based on race or religion or whatever. And the Supreme Court said that that is not the way you can address affirmative action. That doesn't work. It's too mechanical. It's not a proper look at how it affects the education. As opposed to the law school method, it was a factor in determining admissions, and they said that they needed to have a broad-based group of people learning because it improved the educational environment that they were learning in. So it was just one of many factors, and it wasn't given a particular weight in how they addressed it.
But as a result of that case, in 2006, Michigan voters approved a law that basically
banned
the
use of
affirmative action.
Yeah.
Comment, if you will, on the fact that someone raises this as an issue and it goes to court. It goes to a court, it goes to an appeals court because someone doesn't like it. Now it goes back, it stands up, and then it goes to a Supreme Court. What would you say about the fact that there's been such a contentious debate that it ends up taking up an awful lot of court time at various levels, both in terms of fact and its overall constitutionality, which is what the Supreme Court has to grapple with, I suppose.
And the lower courts.
And the lower court as well. So what do you have to say about the fact that it's gone on as such a contentious issue over 30 years, however many years it's been? 50 actually.
51, 52
Right.
years.
So, well, they're important issues. And you can be on either side of that issue as to whether you believe affirmative action is necessary or it's no longer necessary or it was at one time and isn't now. And whatever your opinion is on that, you should have the right, and that's what the court system's for, to challenge the constitutionality. And that's what the federal court system is. One of the things it's designed to do is to interpret our Constitution and determine whether or not someone's violating it. So it's appropriately there. Now, what side of the coin you're on will depend on whether you think the court makes the right decision. But the fact that it's there, it's where it belongs.
So when they originally talk about having the discriminated against class, whether it was the sex or in this case the race, to have the race then become the predominant factor, not the only factor. Does that make it constitutionally okay? Does that make it okay to just to have that be the predominant, not the only, but the predominant factor because they want diversity?
I don't think the court would accept that.
No, I don't think they would accept that. You have to take it as a whole, so
Right.
it can't be just one particular group. It has to be, you know, you have to give regard to race, color, religion, and oddly enough, gender wasn't added until the late 60s, and sexual orientation as well.
Right.
But again, you would...
The admissions still has to be based on all the other factors that would go into a college or a law school or a medical school accepting a student, which would be their SAT, high school grades if it's for undergraduate admission, all of those things. The use of race as a factor, I think, at least in the Michigan law school case, was approved. If it were the only factor, or let's say the predominant factor, I don't think the Supreme Court would find that to pass constitutional muster.
Again, you're excluding all other
Right.
individuals that would qualify. So if somebody had a perfect score on an SAT, they would be excluded if race was the predominant factor in that particular case. Maybe you would be getting affirmative action is giving a diversity among students, but it's actually now acted in reverse.
I guess in the days when Sandra Day O'Connor was first addressing it, one of her statements is continually brought back as, perhaps in 25 years we won't need to revisit this issue because it will have been a moot point, it will have outlived its usefulness. But of course, we are revisiting it still. They might decide that affirmative action is going to be upended, but that's yet another discussion. When you talk about having the interest in having diversity, and then the next step is critical mass, I guess how contentious could it be to say, what exactly is critical mass? How many of females, males, Hispanic versus Latino versus black versus, how do you possibly manage to take that as a sole factor?
Well, here, let's start with something that you were saying about Sandra Day O'Connor. That's exactly what I was saying, is that things change. Now, whether affirmative action is necessary or not necessary, I think more likely what's going to happen is the courts may look at groups differently. It may not be necessary for one group as it was in 1960 as it is today, but it might be for another group. The other side of it is, you were talking about percentages, this and that. One thing I think that will never hold muster is so-called a quota system. You have to have at least this number of this group and this number of that group. That's not going to work either, because that's clearly discriminatory, and it's clearly not based in any reasonable, rational way of admitting students to a school of any type.
It would be good if everyone could be, as they say, colorblind, asexual entirely, not having to factor that in. When you look back on it, it seems that there have been plenty who've said we wouldn't have had a chance any other way. These days, there seems to be more students who are saying we have a good education. In fact, some of the Hispanic or blacks actually might be very privileged, very well heeled, and then certainly have opportunity afforded to them that they might not have had back in the 50s or early 60s. So does that counterbalance this issue entirely, or does it still make it worth having the conversation?
Well, are you saying that only the affluent of that particular group are receiving the benefit of...
No, I think what she's saying is that since there's now a group of that social economic class that is on the higher end, that we don't need affirmative action anymore because they're not being discriminated against. They've made it, so to speak.
Yes, and right? While I'm saying that, it was actually one of the Supreme Court justices was raising that issue too. Well, how do you counterbalance what was perhaps a racially disadvantaged group now becomes a privilege, but perhaps still disadvantaged in terms of numbers, but certainly not in terms of access to things that would give them better SATs, et cetera.
And my recollection, and I don't recall exactly what he said, but Clarence Thomas is one who was never a big fan of affirmative action and didn't feel it was necessary and all of that. But part of diversity is also social economic diversity. So some schools, if they can, like to be need blind when they're doing their acceptances and looking at applications. That's as important an issue to me as some of the other groups, as you said, that may have no longer been discriminated against to the point where affirmative action is necessary. So there's a lot of different ways to measure diversity. And I think that's part of what the Supreme Court was saying in the Michigan undergrad and Michigan law school cases, that let's not do this mechanically. Let's look at the broad picture and what are we trying to create for a class that represents the world as best we can and also represents the educational cohort that we want to create so that the learning environment is as good as it can be.
I think what will probably happen once they decide this case is that they will uphold the constitutionality of affirmative action as it applies to education, but they're going to say you can't give as much weight to certain areas as it can't be the sole reason why you're accepting a student.
Well, that perhaps brings to mind the University of Texas story, the more recent one, which was 10% of the class, upper portion of the class gets accepted and this gal is denied, but it's beyond the 10% cutoff. She had a wonderful grade point average and other things going on, but nevertheless she's denied. And she says, well, I'm denied because I'm white. Well, now her being white isn't just an issue about quota system because the 10% across the board already took care of the idea of diversity. I don't know if it tested critical mass, but it certainly takes care of diversity. So now this other layer of the University of Texas issue is back on the table because she might have something, an issue to raise, but it's certainly not just about there weren't enough of whites, there weren't enough blacks. It's not about quotas. It'll be interesting to see how that one plays out as well. You mentioned the social economic situation, and I guess when they talk about affirmative action, you'd like to up the ante, increase, or make a better educational environment. So some would argue that if you, for example, put the underprivileged, Black, Hispanic, whatever group you want to refer to, if you put them in the group of other law school students who made it based on their GPAs and their LSATs, might you be setting them up to fail and actually hurting the very individuals or groups that you are intending to benefit? Because if they struggle, if they aren't of that same socioeconomic class, they may feel inferior, may struggle, may fail, may be in a worse situation.
I think what's happening, though, is if the person is underprivileged financially, I think those groups, they're only receiving students of wealthy backgrounds in those particular groups. So I think in this case, the underprivileged still are not having the same opportunity as the privileged African American or as the privileged Hispanic.
And if the school goes through its same process for acceptance, that is to say that you look at the grades or the test scores or whatever it is that you base your projection that someone can succeed in your program on, what we're saying is that there's certainly qualified people in every group that could be admitted. And so you don't admit someone just because they fall into a group that would otherwise be protected, so to speak, but that you accept the people who can succeed from those groups.
Okay, so, and to that point, when this very specific case was, one racially disadvantaged class, happened to be a Black person, ends up receiving a 310-point bump to his...
Now you're getting to the point system.
Well, to his exact LSAT, and a couple of points because of his grade point average. Okay, so is that balancing the system, or is that being unfair to the student who worked, struggled, whether she was white, whether it was male, female, Black, white, or green? Fact is, what are the chances of that person succeeding if they had to have their grade point average bumped up in their LSAT? Maybe they're not really capable of being in that particular school. And maybe you might say, would they be better off if they were in perhaps not the Ivy League school, but in a better school in a class of their peers?
But there are studies that have resulted in exactly what you're saying, because that particular student that was in that particular school, same thing. They were in a situation where they probably didn't qualify educationally, and so they didn't perform as well. And then that same thing is somebody that has a higher grade point average should have taken the place, but it takes a spot away. It takes that person's ability to go to that particular school. It removes them from that category.
I think it's a little skewed. Mm-hmm. I think that if it were strictly that, and I don't know exactly the case study that you both are speaking of, however, I know that based on the Michigan cases, that if it were mechanical and you were adding numbers just because of race or whatever, that's not a system that passes muster. What I'm saying is there are people in every class, every race, every segment of society that are qualified.
Sure. And
that those people shouldn't be discriminated against, certainly, and that if you're trying to create an educational background or group that provides diversity, it can be a factor in how you put your class together. It can't be a mechanical factor, though. So you can't just bump somebody up because of that. On the other side of that coin is, I've heard, and I'm not an expert on education or on SATs, but that those tests have been said to discriminate against different groups too.
A very valid point. Of course, now when they're just starting to do the data, what happens, they will talk about some quantitative outcomes that might not be foolproof yet. But apart from the quantitative, what about the qualitative? What about that somewhat underprivileged person for having been put in a situation where they struggle a little bit more but did make it? And they also made some incredibly wonderful connections, which of course is what many will say the advantage of going to a higher level premium school might be. Maybe that person gets to achieve more than he or she could have otherwise. still the point remains, as with this University of Texas, 10% of the high school kids off the top go into this particular school, and then the rest of the admission criteria is personal achievement index. And factoring in some of those things seems like it gives you a very wide swath to balance off the spectrum as you want to. But if you happen to be denied, you could see why this ends up causing a court case,
Sure.
and then some.
And that's always been what causes the court cases. It's the person. I didn't apply to the University of Michigan, so I didn't get a chance to be denied there. But certainly, if you felt you were qualified to be accepted, in that you felt you were bumped out because of a mechanical system that was otherwise unfair, that's where the challenges come from.
Oddly enough, as a result, 38% of the students in that university are Hispanic. And then I believe that 12% are African American.
In Texas?
It's Texas.
Texas.
University of Texas. Yeah.
Interesting. So they certainly have critical mass.
Yeah, they
And
do.
then some.
But now she falls outside of that top 10%. Again, getting back to the mechanical part of it, that's certainly not fair.
Right. And it's interesting because you could say, I don't know that it is, but that just accepting, if you're in the top 10% of your class, you will be accepted.
But that's not what's happening.
Right. So if she was in the top 10% of her class, I assume she wouldn't have been denied. Does that create a diverse group in Texas just by going through that process? I don't know the numbers, I can't comment on that, but I think that is an interesting approach that they've taken. You don't complain if you're in the top 10%, you're getting in.
Yes. So if we use this as a springboard and then talk about affirmative action, say even in the workplace, if you apply for a job, I suppose everyone has to have some policy about affirmative action. How does it get presented so that it's not a contentious issue if you are an applicant? You want to know that everybody wants to have an equal opportunity, and you want, as an employer, I suppose, to let everyone know that you're doing that. That has become contentious too.
I don't think there's a requirement for affirmative action.
Well, there is, if it's somebody that is receiving federal funds.
Federal funds.
So it would be the universities that get
Right.
federal funds. But I think what you're talking about is equal protection.
Right, which
Yeah.
I was going to say, civil
Right.
right protection.
Yeah,
You
civil
can't
right.
discriminate against somebody. That's clear. That's what I was going to say.
And not just disabilities and
All across
but
the board.
Across the board.
Yeah, you cannot not hire somebody because they fall into one of the protected classes, or any class, really. You can't discriminate based on race, religion, age, gender. None of those factors can be considered in an application.
Those that receive federal funds are mandated to comply with affirmative action, and they actually have to have an affirmative action plan.
Right, that's different. That's if you fall under a program where you receive money from the government.
And I suppose if you are such an employer, you would have, not the handbook, that's after someone's
Right.
accepted, but
A
while
policy.
while you're applying, you would want them to know about this. Now, is there such a thing as a quota if you are an employer such as one who's receiving federal funds?
I don't think there's a quota, because if there was, now you're going to end up back in court.
Right.
Yes.
But you have to have the same intent, and it's to promote opportunities
Right.
within a selective class.
Right. So if you do work that is funded by the federal government, you would have to have a policy in place that shows that you are giving opportunity to those protected classes, and that there's a program in place, a policy in place to do that. But you do not have to have a certain number percentage of this, that, other thing, because I think those programs automatically would fail when challenged anyway.
Well, I think what good has come out of it, too, is women have now more opportunity, because now you have a class of women that are able to apply. They fall within that minority group, so now they have opportunities to bid on federal jobs.
Yeah, and there are different organizations that will qualify you as a minority-owned corporation or a woman-owned corporation
WSB.
that
Yes.
get you on a list that you are able to apply for federal jobs and even some state jobs.
And of course, this is the issue about age, too. Now, suppose you are applying for a job. Are you likely, most people will go to the internet and try to Google the company and find out a little bit about the company. So as you are about to be interviewed or sending in an application, do you need to ask about someone's policies? How do you approach that? Or how would you suggest that someone, and on the other side, how would you suggest that someone handle it if they think that they've been discriminated against because of their age, religion, sex, politics, whatever?
Well, if you're going to a website, I would think that the company's policy would be included in their website.
So a good point is to go look.
Go look. You definitely have a right to ask.
They check you out, so why not check them out?
And your employers require, the state Division of Employment require you to put that poster on your
someplace where it's public.
What happens if you're discriminated, if you feel you're discriminated? There are a couple avenues you can pursue. One is the state of Rhode Island, also in Massachusetts, they do have a division of Massachusetts Division Against Discrimination, so that you can apply there, or you can file a complaint with them. In Rhode Island, it's the Human Rights Commission. You can apply. It doesn't cost you anything. They do have people there that will investigate your claim, and it's very specific. So you have to have an answer within a certain amount of time, and after a particular amount of time, you can remove it from there and bring it into state or federal court on the constitutionality or the racial bias or whatever it is.
So there's certainly something in place, and if someone believes that after they've done this preliminary search on their own and they really think that they have a case, is that a DIY, do-it-yourself kind of case, or is that something that you need a lawyer?
Well, yeah, you definitely need a lawyer, but those that do not have the money can begin with your state division of Human Rights Commission.
And in fact, even as a lawyer, I will tell you there are lawyers who specialize in those areas, and I would want to be speaking to an attorney who does that. As I know we don't sanctify the special, you can't specialize in things, but there are attorneys that concentrate in that, and you want someone who knows those areas because they are specialized.
And you started to refer to something a little bit earlier, and that was the distinction, which we didn't have a chance to clarify, maybe we do briefly now, about the disabilities. You are applying for a job, and you perhaps have some disability, but you still could perform the job with some minor consideration.
So that's the American Disabilities Act.
Yeah.
And someone needs to perhaps look at the ADA website to see if they think that they're being discriminated against both in hiring and when they're actually working as well?
Right. It's the answer to that simply, and I know we've done whole shows on this before, is if a simple accommodation can be made so that you can do your job, that's not grounds for you to either not be hired or to be fired. You can't be discriminated against because of a disability. That can easily be accommodated.
Sounds good. We certainly covered a lot of topics. We talk about the Supreme Court just for a few minutes here. Is that likely to be affected by who's on the Supreme Court right now? Because every time that comes up, there's been a change in the composition, even one who's going to be recusing herself.
There is a recusal. It was Kagan, was it? Yeah, she recused. So what might happen is a 4-4 decision, which would basically...
What would that do?
That would basically
uphold whatever the decision
that was
appealed
in the lower court.
And does that mean that it goes back to the individual states to deal with whatever they're going to deal with?
It keeps that decision in place the way it was. And also remember that the composition of the court always determines what happens, because it's the justices who decide the cases.
I wonder if you think that right now it means that it's more likely to be declared not valid to have affirmative action anymore based on the composition. Care to wager?
It's interesting. I think it would be a 4-4.
Yeah. Well, and also remember you have, I think, a challenge coming up to the Michigan constitutional amendment.
Yeah.
And that'll be an even more interesting way to weigh in on what happens with affirmative action.
Well, we had a little bit of a debate about that. Thank you very much for weighing in on that. We hope that this has been helpful to you in discovering what you need to about affirmative action and whether it applies to school admissions or hiring policies. Thank you for tuning in. The discussion of legal matters will continue.